My name's Dan Jackman, and I'm an Assistant Chief Reporter at the Planning and Environmental Appeals Division, and my colleague is Mrs. Lorna McCallum, who is a reporter. We have been jointly appointed by Scottish ministers to hold an inquiry into the Whitesands Project Flood Protection Scheme and prepare a report for their consideration. Before I go any further, just the usual housekeeping points. We're not expecting a fire alarm practice, so if we hear the alarm, it's for real. If we hear the alarm, I suggest that we stay calm and leave by the most appropriate exit, which is behind us. The assembly area is the car park, and no doubt the staff will be there to assist. The toilets are back in the corridor that you came along. If you're facing the foyer, they're to your left. Can I ask that all mobile phones are turned off, please? I also would like to remind people that these proceedings are being webcast live. So you'll be able to go home and watch yourself on TV if you wish later on. Can I just check? Can everybody hear me okay? Is good. An important person I need to mention is Mr. Scott Mackenzie. Unfortunately, he couldn't be with us today. Mr. Mackenzie is the case officer for the inquiry. He is responsible for looking after the file and making all the administrative arrangements on our behalf, and through whom you should go through if you have any questions or want to contact us. We're also assisted today by Mr. Ewan Murray, who is the technician in charge of the webcasting, and Mrs. Jane Robertson, who's a case officer standing in for Mr. Mackenzie and is on roving microphone duty. In most inquiries that I've been involved in, there are usually some main participants, the lead characters, if you like, who articulate the main arguments. That does not mean that no one else can take part, but no useful purpose is served if you're repeating a position of one of the main parties. In this case, the Council is promoting the order and is clearly a key party. So can I ask the Council team to introduce themselves to the meeting, please?
Thank you, sir. My name is Craig Connell, QC of Pinsent Masons, and I'm representing the Council today for the purposes of the present meeting. I'm accompanied by Mr. Adrian Pringle from the Council, who's been doing a lot of the correspondence involved in the matter, and other names that people may have seen in the exchange, because I won't necessarily go through everybody who's here. Miss Emma Reid to my right and Miss Fiona McGregor to my left. Thank you. I'll repeat that. Apologies if that wasn't audible. I was simply pointing out that to my right, Miss Emma Reid, who has appeared in some of the correspondence, and to my left, Miss Fiona McGregor, who's also appeared likewise. Thank you, sir.
Thank you. From our email correspondence and having looked at the objections, it appeared to us that Save Our Sands group represented the views of a significant number of objections. Can I ask if the Save Our Sands group could introduce themselves to the meeting, please?
Yes, okay. My name is John Nowson. I'm a town centre resident at 54 Bank Street, which is above the flood level. But I've got representatives here, and perhaps I could ask that they maybe introduce themselves. I think that would be the best way.
Okay. My name is David Slater. I'm a retired business person from Dumfries, and I raised the SOS petition.
My name's William Potts. I'm a local businessman in the area that's concerning the flood prevention in the Whitesands.
My name is Alex Girwood, a retired picture framer for 37 years in Dumfries, and just concerned about the project.
My name is Brian Sherman. I have a business on the Whitesands. I'm also leader of the Dumfries and Galloway Federation of Small Businesses.
My name is Peter Batchy. I'm also a Whitesands trader. Have been for over 34 years in the Whitesands. Likewise with Brian.
John Greenwood, also a business owner on the Whitesands.
Thank you. As I go through the rest of this agenda, I will initially address my questions to the main parties, as usually they have the most to say about procedural matters. If you're not aligned to one of the... Oh, sorry, I forgot a very important point there. Is there any other persons present who would consider themselves to be a main party? So, this gentleman.
Okay, my name's John Glover. I'm a resident in the Nunham area of Dumfries. I am a representative of a number of the Nunham residents who are here with us today, but essentially I represent a group of residents who were not formally notified under the flood prevention scheme, and we are here to represent those views at this moment. And I would like to speak later on, if I may. Thank you.
Okay. The hand up.
My name's Tom McCartney. I also live at Nunham. I live at the lowest point of the river there, and I have my concerns about the knock-on effect of this on my property. Thank you.
And I think at the back.
Thank you. Oliver Mundell, Member of the Scottish Parliament for Dumfriesshire. I've been contacted by a large number of residents in the town, both upstream, downstream and in the town centre, and I wish to make a number of objections on their behalf.
Thank you. Have we captured all the hands that went up there? Okay. So, as I was saying, as I go through the agenda, I'll address my questions on procedural matters to the main parties, because usually they have the most to say. If you're not aligned to one of the main parties, that does not mean you can't take part, and there will be opportunities for you to make comments. Just raise your hands and the roving mic will come along. Can we now turn on to item 2 of the agenda? The aim of this meeting is for the objectors and council to discuss our initial thoughts about how the inquiry process can be organised, and hopefully obtain agreement on the final form so that everyone can go away and prepare with a firm timetable in mind. It is not an opportunity to discuss the merits of the cases, and I shall not allow any such discussion. We are aware that a number of people have objected to the legality of the order and the notification arrangements, which in their view have denied them their rights as objectors. This includes whether the inquiry should proceed at all. We will discuss how we should address this matter under item 4. By way of introduction, I want to say a few words about our role as reporters and what we do. Scottish ministers have appointed us to hold a public local inquiry into the objections made to the order. The words public local inquiry are frequently used in the media, but for us it has a particular meaning. It is specified in the Flood Risk Management Act, and we'll come on to that in item 3. But we have no authority, we only have authority to carry out the remit given to us by Scottish ministers. The reason we are called reporters is because we report back to ministers to help them reach their decision. In this case, whether to confirm the order, amend the order, or decide not to confirm it. The way we will do that is by writing a report. We will come on to this under item 5, but typically our report would be structured around various topic matters. Typically a topic would represent a chapter. For each chapter, we would summarise the cases for the objectors, we would summarise the case made by the Council, and we would explain to the Minister the differences between the objectors and the Councils and the reasons for those differences. I would like to stress that all duly made objections will be considered in our report. If you made an objection and wish to expand on that objection, you may do so, either by further written submissions, by participating in a hearing session, or by participating in a formal inquiry session. We have previously asked objectors how they wished their objection to be considered. You do not need to finalise your choice this evening, but once a framework has been agreed, it becomes increasingly difficult to make changes. We are happy to hear further evidence, but we want to hear that in a structured way, which would help us write our report. From our point of view, it would be best that the topics we heard more evidence on were in a logical order, and that we didn't hear duplicated evidence. We made some suggestions in the annexes that were attached to the agenda, and about how objections could be grouped further evidence. But we have no firm views, and we can discuss this under items 5 and 6. The timetable and daily routine will be discussed under items 7 to 10. I would add that some people think the purpose of an inquiry is to persuade the reporters of their point of view. It is not. The purpose of us hearing further evidence is to help us understand your respective positions. We cannot do our job until we understand the arguments being made to us. I can assure you, Scottish ministers will persuade themselves. Therefore, everyone taking part in this inquiry is taking part in a mechanism which is designed to help the minister make the best decision for Dumfries. We will be issuing a note of the meeting, which will include the main decisions we take today, and we hope to circulate that as soon as we can, either the end of this week or the beginning of next. Right, can I now turn on to item 3 of the agenda, the Flood Risk Act 2009 and the associated regulations. You may be interested to learn that we are making inquiry history. This is the first inquiry under the 2009 Act and the regulations. Previous schemes, there have been flood defence schemes, not very many, but they were dealt with legislation that has now been repealed. The Council published its order in February 2017. The Council made a preliminary decision to confirm the order in June 2017, and as they are required to do, they submitted the scheme to the Scottish Government. In October, Scottish ministers decided that an inquiry was necessary. We were formally appointed in March of this year. The 2009 Flood Risk Management Act, in Regulation 7.2, Schedule 2, just says that there should be a public inquiry. It refers to Section 210 of the 1973 Local Government Act, but if you should go to that section. It gives very little guidance as to how you should do the day-to-day hearing of evidence. So as is normal practice in those situations, and to help parties who wish to give us further evidence, either in a hearing or an inquiry session, we are proposing to use the hearing session rules and the inquiry session rules used for planning inquiries by analogy. Can I ask, is the Council satisfied with that?
Yes, sir.
Thank you. Save our sands? Pray tell me why.
Well, first of all, it's quite interesting that we're making history, and history indeed. And as far as I'm aware, there is no precedent under the Flood Risk Management Act for these procedures. As you say, there has never been one. The planning procedures that are being suggested are procedures that relate to planning matters. Now, I have specifically asked whether this is a planning inquiry. And I have been told by Scott Mackenzie, by everyone around, and by the Council themselves that this is not a planning inquiry. That raises a question then whether planning procedures are appropriate. In terms of the purpose of the meeting, Mr. Scott Mackenzie advised me that the purpose of this meeting was to agree procedures and to try to ensure that all parties would be happy with those procedures. Now, there are certain parts of the procedures that we are a bit unhappy with. In broad terms, can I just maybe go back a little bit as to one or two other things that you said? And I would like you to perhaps confirm whether this is a planning inquiry or not. Do you have any statement to make on that?
I was going to let you finish, but I can assure you that this is not a planning inquiry. It is inquiry under the Flood Risk Management Act 2009.
Okay, but just for the help of the public then, they should be aware, and I'm sure I'll be corrected if I'm wrong, that in terms of the Council's proposals for the Whitesands, they effectively have all of the approvals that they need apart from planning permission. So although this is not a planning inquiry, the purpose of this inquiry is for the Council to secure planning permission. Very interesting. It's not planning inquiry, but the outcome, the only outcome that has really been sought, is planning permission. That planning permission would ultimately be given by the Minister or the Ministers, and it's referred to as deemed planning permission. Now, at a very early stage in this whole proposal, I raised this with the then chairman of the appropriate committee in the Council, Colin Smith, who is now an MSP, and suggested to him that really a planning application was required because the Council would require planning permission. I was advised no, they were going to do it under the Flood Risk Management Act, I think it's called. That means that the only way they can get permission is through a minister giving deemed planning permission.
I hate to intervene, but I fear we're digressing slightly. What I was asking was, since there are no detailed rules in the Flood Risk Management Act, just for the day-to-day hearing of evidence, we'll come on to your deemed planning permission point later on, but just for the hearing of day-to-day evidence, for hearing sessions or inquiry sessions, I was proposing to use the rules that we use for those things at planning inquiries. What is your particular objection to that suggestion?
In broad terms, I can only, I hope I'm speaking for the others here. I would go along with that, but I have already written to you, I don't know if you have a copy, and I suggested that there may be some conditions or amendments to that should be considered.
Okay, I have indeed been forwarded your email, and I'm happy to deal with that after I've done my little bit about. So this is just the rules for how we deal. So for the day-to-day hearing of evidence at hearing sessions or inquiry sessions, I think I heard you agree that those rules will be okay. Does anybody else have any views on that? Yes, Mr. Munday.
I'm concerned that by choosing to use planning rules, it will make the inquiry more formalistic than it's intended to be. The fact that the Act itself doesn't specify what form it should take, I think, should allow the reporter to operate with discretion throughout, given particularly the large number of views I expect will wish to be presented from people living in the local community. And I fear that the use of the planning rules will only serve to benefit the Council, who are much more familiar with those technicalities and who have the advantage of professional legal advice being paid for at the cost of, we think, in the region of £100,000 out of taxpayers' money.
Thank you. I'm just talking about the actual rules for the day-to-day hearing of evidence. So if we had a hearing session and the inquiry session, it's how are those to be run? And since the planning appeals is the most common form of that, that's why I was suggesting we follow those. I wonder if it's a comfort if I read to you Rule 5, which said the procedure at a hearing session shall be as the appointed person determines. Would you take comfort from that?
Yes.
So are you happy that we use the hearing session rules and inquiry session rules solely for the purpose of the day-to-day hearing of evidence?
Provided that they don't prevent anyone who lives in Dumfries from taking part in any of the given sessions should they wish to.
Well, I think that's a separate matter, which we'll come on to under item 4.
Well, I'm not able to agree to those terms unless we can have an assurance now that planning rules won't be used to prevent local residents in the town from expressing their views in relation to the inquiry.
Right. Have you actually read the hearing rules and inquiry rules?
Yes, I have, but I'm looking for a reassurance that those rules will not be used in this instance to prevent local residents from Dumfries from expressing their views in the inquiry should they wish to take part in a session.
There is nothing in the hearing session rules or the inquiry session rules that gives us any guidance as to who can take part in the hearing or inquiry. It's solely about how that evidence is given. The matter of who is allowed to give evidence, whether you object or not, is something that I wish to discuss under item 4. Are you happy that we use the hearing and inquiry session rules?
In that case, I'll be able to move item 4 forward and provide a guarantee that people who live in Dumfries town will not be prevented from taking part in the inquiry should they choose to do so.
Well, I'm going to discuss that under item 4. We're under item 3 at the moment. Do you want some time to read the rules and tell me what you have difficulty with?
Well, if that guarantee can be given, I'm happy to move on.
Okay. Well, I think in a roundabout way that we've agreed that for just the day-to-day hearing of the evidence, who is entitled to appear is a separate matter which we will deal in a minute. That we will use the hearing session rules and inquiry session rules by analogy. Now, before I move on to item 4, as you mentioned, Mr. Dowson, in your introduction, you had a number of procedural points, and I think I took from what you were saying that you wished to persuade us we were able to use our discretion in some of those matters. I wondered if you wanted to introduce those suggestions now.
Okay. Well, we've agreed to use the planning. Okay, I'll go along with that, but it was subject to perhaps amendments and conditions that have to be agreed between us, and it's in the context that there are no written rules. So if there are no written rules, we can do anything as long as we kind of agree. Well, within reason. Okay. All right. Now, the first one I wanted to raise with you was, as Mr. Mandel said, was about costs and lawyers. We, on this side, are sitting, the way we look at it, with no big guns, whereas on that side, we see a lot of big guns pointed at us. We don't have any lawyers. We don't have any architects, surveyors, engineers, whatever. We don't have £100,000 to pay for lawyers to come and assist us in representing this side. We haven't spent £5 million over the last 6 years with Michelle Engineering and Consultants. So, but we and other objectors here have to try to make an effort to contest that. Now, we're unhappy with the confrontation nature of this. We're unhappy that 322 objectors, that's where it started from. You sent out your 4 tick boxes. Only 122 replied. We're down to, if you look at those that chose option 4, we're down to about 20 or so people out of 322 objections. Now, one of the major reasons for that is this confrontational nature. We come here with a view to cooperation, to trying to work together in partnership with the Council to find the best solution. But we find it very intimidating that the first thing the Council does is then appoint lawyers at £100,000 worth before we even get started. So we would like to ask you to use your discretion. I believe you have it under Circular 6, 1990. I know there are conditions within which you can only use that, but we think it is unreasonable for the Council to behave in this manner. And one of the conditions that would allow you to use your discretion is that unreasonableness. And we would therefore pose 2 potential outcomes to getting an agreement on this. One is that some costs are awarded to our side to then be able to bring in professional people to perhaps challenge in a meaningful way some of the assertions that the Council have already put down. And in order to do that, we would need to have access to some architects, surveyors, hydrologists, engineers, and perhaps lawyers. That is one way forward, is to give us some costs on this side, and we could then share them with, hopefully, with other objectors. The other alternative is to remove Pinsent Masons from this inquiry. And we think it's unreasonable that the Council are using our money to come here and fight with us. We don't think that's a very good way to start this off. The only solution I can see is that we ask them to withdraw, or that we are given some kind of armoury here so that we can get what I think in legal terms is an equality of arms. Because there is no equality of arms here. This is not a fair way to proceed. It's not fair to do that to the people of Dumfries with their own money. So I've suggested two changes. Either we get some costs, or we asked the lawyers to leave.
Right, well, I don't think Circular 6 1990 is going to help us very much. That relates to award of expenses if behaviour is unreasonable.
Absolutely.
It's open to you to make a claim. Usually that is done, however, at the end of an inquiry, and the decision would be taken by the Minister. We would write a separate report, and we would have to assess any claim and the Council's reply to that under the terms of that circular. If you haven't read that circular, I would invite you to do so. It gives examples of unreasonable behaviour, and I don't think your situation falls into one of those. Your email also referred to the provisions of the 2010 Local Government Act 1973, which says that the Secretary of State, at the time, may make provision for expenses. I'm happy to ask the case officer to go back to the client division and seek their views on that provision. I wouldn't want to deceive you, though, that I am not aware of the government ever paying parties' expenses, but I'm happy to ask the question on your behalf. I can't stop any party from appointing legal representation. I just can't do that. In terms of, I want to try and give a little bit of reassurance to some of the points you made there. All objections will be considered. It's not that 322 has been reduced to 20. That's not fair. All objections will be considered. And we have a choice of how, if parties wish to give further evidence to us, we're very happy for that. There are choices as to how you do that. And those choices are further written submission, hearing session, or inquiry sessions. If you elect to give us evidence through inquiry sessions, then there will be cross-examination. What I would say is that I would invite you to forget every courtroom drama that you have ever watched. Cross-examination, you're not up for murder. A cross-examination is solely for, it's just a question, and we will not permit parties to ask questions aggressively or inappropriately. And of course, if you elect to take part in inquiry sessions, you too would be entitled to ask questions of any opponent witnesses. You had other points, Mr. Dowson, which I'm going to try and deal with. Can I suggest your bullet points on witnesses, your choices about hearing or inquiry sessions, the duration of the inquiry, the topics? We can all address those under items 5 and 6 later on in the agenda. We're going to talk in a minute about the notification situation. And for public realm improvements, again, if you wish to, in your evidence to us, extra evidence to us, you want to tell us why you feel the order, so the scope of it is wrong, then that's entirely open to you to do that, and we will hear that evidence from you. Is there anything else? Do you think we've done with item 3?
If I could just comment, I mean, you did mention there that you could make an approach to the Minister or to the Secretary. Is that?
What I said I'd undertake to do is I will ask the case officer tomorrow to ask the client division, because we're hired guns, we've been hired by the Environmental Quality Division to hold an inquiry. I will ask the case officer for the Clients Division's view on the provisions of those sections that you've directed me to, and we will obviously report back.
Yeah,
I think that's the best I can do, I'm afraid.
I appreciate that, and I would ask you to do that. That's really all I'm saying, because we are making history here, and there is an opportunity then for that Client Division and the Minister to take an initiative here and award us some costs, which would make this a much fairer, in our opinion, exercise. Thank you.
Is there any other points we need to discuss under item 3?
William Watson, Dobiti. I'll put an objection in. Now, I'd like to ask Mr. Mandela a question. Now, he's talking about only objections.
Whoa. We're going to spend a very long time at this meeting if we don't stick to the agenda. We're looking at item 3, and it was just about the legal provisions of the 2009 Act. Are you satisfied that we've dealt everything we need to deal with under item 3?
There was a step to keep people outside Dumfries from asking questions or objecting.
Well, I'm sure we're going to come on to this in item 4. I think there was another gentleman at the front there. Just a gentleman there.
Yeah, simply to be brief, I concur with the view taken by the Save Our Sands group in terms of seeking information through the case officer for support for costs. I think this is a vital area of this pre-inquiry discussion, and I would strongly endorse that move is made so that at least we have a definitive answer about whether costs to support independent or alternative hydrological and technical review is made available to those who are objecting. That way, I think we have a fair playing field.
Thank you. That's noted, and you're on TV. Right, can we now turn to item 4? Outstanding procedural matters. On the 27th of April 2018, we received a letter from Morton Fraser's solicitor on behalf of residents in Nunholm Road, Nunholm Park and Albany Lane area of Dumfries, some who had made objections and some who had not. In summary, it stated that the council had erred in making its notification arrangements, and a number of local residents should have been notified but were not. We forwarded this letter to the council and received a reply on the 4th of June, which in short disputed that there had been any procedural flaw. On the 25th of May 2018, we received another letter from Morton Fraser stating that the environmental statement did not comply with the relevant regulations and was therefore fundamentally flawed. We copied that letter to the council on the 4th of June. The advice from Morton Fraser on both counts was that the inquiry should not proceed. For the Nunholm residents, is there anything you'd like to add to that point?
Hello, my name is Pauline Fisher and I live at 57 Nunholm Road. I know that you've ruled out having legal exchanges today on the failure of the Council to notify anyone in Nunholm of the period in February 2017 when it was only possible to submit a valid objection to the scheme. Had I and many of my Nunholm neighbours been notified, we would have objected. This exclusion has profoundly prejudiced us. Some of my excluded neighbours are here today and they have agreed for me to represent their views, as have those who could not be here today. Our solicitors Morton Fraser have sent out for you why we should have been notified. Morton Fraser tell us that the response sent to you by Pinsent Masons did not contain any appropriate justification for this failure by the Council. To compensate for the increase in flood levels, which the Council admit the scheme will cause in Nuneham, material is to be removed downstream. Even the most rudimentary analysis of what the Council have put online shows this mitigation measure to be a very questionable proposal in terms of reliability and practicality. The Council should also have known that 2 houses were flooded and some 50 other houses and a business were made inaccessible during Storm Frank in December 2015. Incidentally, one of those flooded houses is owned by a person that was abroad in February 2017. By any stretch of the imaginations, persons in Nuneham may be affected by the alteration in the flows of waters caused by the scheme, to paraphrase the wording of the Flood Act, and should be notified. I know you've decided not to rule on this and just to leave it to ministers when they get your report to do so. Those of us in Nuneham excluded by this defective notification process are frankly at a loss to understand how it can be prudent and sensible to let this inquiry continue, given all the time and expense this will continue to involve, when the legal advice we have received is that there is a high risk that it may only lead to the process to date needing to be reset, possibly to where it was around the beginning of February 2017, to properly comply with the Flood Act. We therefore urge you, if for no other reason that in the public interest, to convey to ministers now that they obtain legal advice that it is safe to continue with inquiry given the magnitude of the possible consequences of this breach. Morton and Fraser advise us that this should not need be delayed until we receive any further submissions or evidence, as there is presently sufficient online, even if only for ministers to obtain a preliminary ruling to try to partly manage the risk they face. Morton Fraser have notified you that none of their Nuneham clients have been represented by them here today. This is due to the cost that this would involve. In view of this, I request that this statement be recorded as a verbal submission to this meeting, minuted and posted on your website with no further debate or verbal exchanges given our lack of legal representation. I would be very happy to email this statement for the minute of today's meeting.
Thank you. If you could do that, that would be very helpful. For the Council, any thoughts or comments on my statement and what you've just heard?
So perhaps I can deal with it in this way. It's obviously no part of this Council's position to seek in any way to restrict the ability of those concerned about this order to express their views on that matter, and you've already dealt with that more generally in your earlier comments. And I should also perhaps point out that as even in the very rough outline that you've sketched out so far, the impact of the works elsewhere, including upstream, including Nuneham, is already scheduled to be a matter on which information will be provided at the inquiry to assist the ministers in understanding the nature and effect of the scheme. So that is already a topic which will be covered in the evidence for the Council. So far as notification is concerned, the position of the Council remains as previously stated, and I don't propose to take up time reiterating that. They don't accept there are any errors in the notification process. Thank you, sir.
It seems to us that on both counts raised by Morton Fraser solicitors, that the legality of the inquiry is being challenged on a point of law. I have to say this is not unprecedented in my experience. As reporters, we have no authority to make a ruling on a point of law. Any ruling we made would unlikely to be accepted by the losing party, and we have no powers to enforce any such ruling. Decisions on the point of law have to be taken by a court. We do accept that Scottish ministers need to be aware of these fundamental legal issues. I'm sure people are aware that Scottish ministers will have access to their own legal advice from Scottish Government's law officers, and obviously ministers would wish to consider that advice before deciding whether to confirm the order or not. We are happy to consider any further written legal submissions the parties may wish to make, and we're happy to pass that on and include in our report either as a separate chapter or an annex or as a supplementary report. But as the Council is happy for us to proceed, we do not believe we have any authority to delay the start of the inquiry. What we will undertake to do is to pass the note of the meeting and your statement to the client division and ask for their confirmation that they are happy for us to continue. But for the purposes of this meeting, we need to plan as if the process was carrying on. Would there be a requirement for further legal submissions? Are you happy with what Morton Frasers have done, or would you like to do more?
Well, again, I think our point remains as expressed earlier. We have no funds to be able to challenge in further legal representation the existing position. But I would emphasise, and I guess this is repetition once more, that I think if there is any chance that this inquiry can be considered in terms of the legality of it, then now is the time for that advice to be taken before we run additional expense against the public purse in holding the detailed inquiry in the future. I do think there's an opportunity to have that legal view considered by the ministers at this point before we go any further on this whole process. And that is the view I submit on behalf of the Nunham residents. We have no funds to further challenge, although we will make further written submission to the inquiry if it goes ahead.
Mr. Mundell, you had your hand up.
Can I express my support for the position set out by the Nunham residents and ask you whether or not you possess the power to refer the legal matter for consideration? I know that it's not something you could rule on, but do you have the power to refer it to Scottish Government law officers? Because I'm concerned that should this matter not be addressed now and come up, it may unduly delay proceedings later on and may eventually delay any agreed flood defences from being built.
Right. What I said we would do is that we would draw the client division, the people who have hired us, their attention to this dispute and ask if they're happy for the inquiry to proceed. I don't think I can do anything else.
That's, to be fair, not the question I asked. I asked whether there's anything that explicitly prevents you from referring this matter? Do you have the discretion to refer this matter to Scottish Government law officers?
I don't think we do. We've been asked to organise a public inquiry and to write a report. As I say, we will ask the client division if they're happy to proceed. As you heard, the council is happy to proceed.
Unfortunately, a number of objectors and local residents are not happy to proceed, and a number of the main parties are concerned that if this matter is not addressed, it may lead to future delays in providing flood defences to the town, and is therefore, I think, something that does need to be addressed at the beginning, because if the inquiry has to be rerun in the future, then that would cause significant issues. And it's not the only procedural issue to have arisen. The required documents were not displayed on the council website during the whole period of consultation when objections could be put in, and the consultation had to be extended, but by that point a number of people had already considered the scheme. So there are a number of procedural flaws, and I think the fact that people who are directly affected by the scheme weren't aware they were affected is a big problem.
I understand the points you're making. My difficulty is I've been asked to hold an inquiry. The terms of that inquiry are set out in the Act. I completely understand the issues about the legality, but that's not for us to rule upon. All I can say is if we pass the legal submissions on and the advice provided by Morton Fraser is correct, then the Minister clearly will not be confirming the order. And I don't think we can move this forward any further. We're happy to receive additional further written submissions. We're happy to go back to the client division and report the discussion that took place. I mean, they'll be able to see the webcast as well, and confirm whether they are content for us to carry on or not. And that's as much as I think I can do.
So if I could just say, because I realise I neglected to mention it when I spoke earlier, so far as the environmental assessment objections, I don't think there has been a formal response to these in the way that there was to the notification issues, and obviously the intention of the Council would be to send a formal response to that, which you could include in the materials.
Thank you. Okay. Yes, Mr.
It's to do with notifications. We would probably have to put in a further written submission complaining about not the Nunham notifications, but the notifications to town centre properties. This scheme has been entitled from the beginning the Flood Prevention Scheme and Public Realm Improvements. And the point I'm making here is that as far as I'm aware, no notifications have been made under the public realm improvements aspect of the scheme. It seems that the Council decided that they only needed to put notifications on those that were affected by the flooding. Now, the public realm improvements involve significant changes to things like car parking, yellow lines, bus routes, all sorts of things. Normally, I would have expected them not to have been dealt with under the Flood Risk Act, but under normal planning procedures. And under the normal planning acts, I would have expected notifications then to be given to all those people who would be affected by the public realm improvements. Now, that particularly would relate to businesses in the high street, retail businesses, shops, everyone who uses the parking, the buses or whatever. In our view, there was a duty on the Council to produce notifications in relation to the public realm improvements, and in our view that has not been done, and therefore we think that there's been a failure there. We also think there has been a failure because the council seem to have taken those affected by flooding as being the 1 in 75-year floodline. I may be wrong in that, it may be a bit more, but we would point out that you can expect 1 in 200-year flood events. It will not just be the 1 in 75-year properties that would be affected by flooding. If the water comes over the top there, it will go a lot further. And we think there should have been a much wider notification of property owners. So I think a whole range of people have been excluded from notifications, and we would therefore add that in support to the Nunham point.
Thank you. What I would say to you is that if you believe that there is legal flaws in the order that is before the Minister, then we are happy to receive written submissions explaining why you think that is the case. We will obviously invite the Council to respond to anything, and we will include those legal submissions in our report. If you have a difficulty with the scope of the order, in terms of what's included with it, it would be open to you in your evidence to us to explain where you think the Council's got that wrong, and again, we would consider that in our report. In addition to that, what I've just said is that we will report back the submissions that have been made and ask the client division whether they are happy for us to proceed. And I don't think we can discuss this any further. I see your hand up, Mr. Mandel. Are we going to draw a close to this? Because I think we really need to move on.
It's an important question. I just wondered whether the view of the legal team will be set out so that objectors have the chance to review and further consider that and take further legal advice.
Any instruction that we receive from the client division will be on our website, so yes. Right, can we move now on to item 5? This is a key item on our agenda to try and move things forward in terms of the arrangements for the inquiry, and I will just repeat a couple of words, some points I made in my introduction. We will be considering all objections that are before us. If you wish to expand on your objection by further written submissions, there is no restriction on the matters that you can include or length of submission, and we'll discuss that, and that's relatively easy to organise, and we'll discuss that under item 6C. For those objections who want to give oral evidence, either by way of a hearing or inquiry session, that's a little bit more logistically complicated for us to organise. We obviously have to prepare a timetable, and we'd like to hear the evidence in a logical sequence of events. Just to remind everyone, there are two ways of giving evidence to us orally. There is a hearing session. A hearing session is a structured discussion that we lead based on statements that have been submitted in advance. An inquiry session is more formal. Witnesses read out their evidence from what's called a precognition, and then they can be cross-examined. We can ask questions as well. We would encourage people who are wishing to give us further evidence orally to group together. There is no point submitting to us duplicated evidence. In our experience of inquiries. People who group don't think that's weakened their case. It strengthens it because it pools resources, and there's nothing wrong for spokespeople to say that they're representing a number of objectors. Because this is such an important matter on the agenda, I'm going to try and break it down into little parts. So bear with me as I work through the different steps. So, the first step. In Annex A to the agenda, we identified the key subject matters that we felt that we needed to address in our report. If you like, the main chapter headings that we would include in our report. And we had background, technical matters, impact on ecology, visual and heritage impacts, impact on the town centre, tourism, parking, other matters and conditions. Can I start with the Council? Do you feel that those are appropriate topic headings to cover the breadth of the objections that are before us?
Subject to the point I made earlier, sir, that there's no intention on this side to try to restrict or confine people unnecessarily. We're content with the broad selection of topics that you have selected. So, thank you.
Save our sands.
Yes. Broadly speaking, yes. We're a bit unhappy with... could I say we've got no objection to certain things being held in hearings as opposed to the more formal inquiry. And I can understand the roundtable discussion is interesting. It doesn't allow for the detailed cross-examination, I understand, that would come under inquiry. So we're quite happy for these hearings to go ahead, subject to the fact that we have got a very large objection submitted to you. Just about every part of our objection we would want to cross-examine on. So we don't want a situation where, because there has been a hearing and roundtable discussion, therefore we can't have a bit of cross-examination in a different place. Now, for instance, if I can just bring out one that I think is very important. You mentioned impact on town centre, tourism, parking, and you're proposing here, I think, to hold that up with further written submissions in a hearing session.
Well, hang on a second. As I say, I'm going to try and do this in little bites.
Okay.
So my first little bite is just to get agreement to the subject matters. I thought in your email to me that you were making some suggestions. I think you were suggesting an additional topic called engagement, and you also mentioned the need to look at compensation for traders and parking regulations.
Yes.
I'm wondering
in broad terms, yes, can I just say that? Yes, we think these are important subjects. We want to ensure that they are covered at some point, and at some point we think they would have to be part of the more formal part, because we might want to cross-examine on these points.
Right, we'll come on to that later. Trust me. If we were to amend our list and include a separate heading called community engagement, and to add under impact on town centre compensation for traders, parking regulation, would you be content with that? Anyone else on the topics? Sir.
Again, we would agree with the point that's been made by the SOS group, but we would also want the impact of both downstream and upstream to be clearly considered within the topics of the inquiry.
If we were to make it clear under technical matters that we wanted to hear evidence about downstream and upstream flooding, you would be happy with that?
Yes.
Any other suggestions? Council, any thoughts on those suggestions? If we modified the topic headings along the lines that have been said, would you be content?
I see no issue with that. So far as the flooding one, I confess I'd assumed impact elsewhere was already designed to cover that, and I've no difficulty with the amending of the wording to make that absolutely plain to members of the public. So far as the other issues are concerned, if other parties believe these are matters on which ministers should be informed, the Council has no issue with that.
Okay, I think we've got agreement then. So that's my first bite. My second bite. In the papers that we circulated, we suggested a framework for hearing of evidence of 2 3-week sessions with a break in between. The reason we had the break was because we were proposing holding hearing sessions, and we would need time to prepare for those. But in terms of a broad block of time, and we'll come on to dates later on in the agenda, but in terms of a broad block of time, is that reasonable? So for the Council, any thoughts on that?
So we find that a little difficult to assess at the moment. And we're speaking, of course, as things stand today, having listened carefully to submissions about other things that might or might not emerge from some of the things that SOS have said. As things stand today, it did seem to us that perhaps what might have been anticipated, for instance, in the technical matters section, was scheduled to last rather longer than we would have thought it would as we are now. And that might suggest that the overall block of time was larger. Now, I can come back in due course to the selection of methods of dealing with any particular type of evidence, because I'm conscious that's probably in another bite of your division.
So, just to summarise that then you're broadly content, if we've erred at all, we've been overcautious.
Yes, sir. I think I was particularly thinking that if the matters stand as they are at the moment, it looks as if it's only the Council that's planning to lead what I might describe as technical witnesses, and I'm just using that as a general term, and therefore the time that might in other circumstances be taken up, perhaps by competing technical witnesses and so on, wouldn't be necessary. But yes, we think probably you're on things as they stand, you've erred on the side of caution.
I don't mind that. I'm happy to lose weeks. It's trying to gain them, which is a problem. For Save Our Sands, any thoughts on a block of time of, let's think, 7 weeks? Do you think that that's a reasonable time for us to get everything done?
Well, we are similar. It's very difficult for us to make an assessment of that. We all want to get this over with as quickly as possible. We can assure you of that. But I think we feel we'll just have to play this one a bit by ear. We've taken on board your timetable. One thing I would say, though, if things have to be said, if things have to be brought out, and if one section is taking a bit longer than you budgeted for, I hope that will be allowed for. And we would intend, one way or the other, to hopefully bring a list of witnesses to you. So I'm not, I'm just trying to help here that just because we haven't got any money doesn't mean we can't call witnesses and we can't find people who may come and assist us. So I'm happy to agree to this in a timescale, but as long as it's very flexible, because we've no way of knowing.
Well, I agree. It's difficult for us as well, because we until we see the inquiry statements and see how many witnesses, etc., it's difficult. But I do like to make sure that there's a good block of time in people's diaries, because it becomes difficult if we'll take however long we need to. But it's organisationally difficult to suddenly add. So we were hoping a block of 7 weeks was a reasonable estimate. And what I'm hearing is, if anything, well, let's say I'm almost hearing that people agree with 7 weeks. Any other thoughts? Does 7 weeks as a block of time seem reasonable? Good. That's my second bite done. Right. We now need to look at the ways that we should hear evidence. When we produced our annexes, we obviously took into account the people who said they wanted to participate by hearings or inquiries when we sent out our letter in the 19th of April. So that was the basis of our suggested methods. I would say that we're extremely relaxed about the method. We're paid the same, whether it's a hearing or inquiry. But I think what I will do is run through our suggestions, and then I'll hear comments from the parties. So the first, looking at the objections, no one had many comments about background, but we feel that we should have a hearing with the Council, SNH, Historic Environment Scotland, Scottish Water and SEPA, and anyone else who wishes to join us, for us to get an understanding of the policy and legal context. Although this is a flood defence scheme, it cross-cuts with lots of other bits of legislation and policies. We certainly need to get that straight, and it's important that the Minister gets that straight. So that's the reason for wanting a background session, and we thought that a hearing session would be the most appropriate for that sort of exchange of information. Looking through the objections, or those people who said to us they wanted to give us additional information orally, there was a lot of comments which we broadly called technical matters, and we were suggesting that should be by way of a formal inquiry session. Looking at the objections from people who said they wanted to give us further evidence, there was not many, well, none I think, who raised ecology. So we were not proposing to have, we will include ecology in our report. We will address the original objections and any further written submissions that raise that matter, but we were not proposing to have any hearings or inquiry sessions on the matter of ecology. Visual impact and heritage was an issue raised by people, and we were proposing to have an inquiry session for that. Impact on town centres and parking and all the related issues were raised in the objections before us, and we were suggesting that would be most appropriately dealt with by way of hearings. You've mentioned engagement as a topic, and we didn't have that, so I'll be interested to hear your views on how we should deal with that. And we also feel that we are likely to hear evidence that the order should be modified in some way, and it would be very important for us to explain the implications of that to ministers, and therefore we feel there should be another hearing session, again with the council and experts, for us to talk through that. And again, we thought that I'll come to you in a minute, sir, a round table discussion was the most appropriate format for that. So that was our suggestions. So I'm going to start with the council. Any thoughts or comments on our suggestions for the mechanisms for hearing additional evidence?
Thank you, sir. Like the reporters, the council doesn't wish to be thought to be trying to impose any particular mechanism in a rigid fashion, and in a sense we've already dealt with the flexibilities that are built in. And just in the context of background, although obviously it's early days, the council did wonder whether it might be of assistance to the general conduct of the inquiry and the information gathering session if a witness was led at the start, basically to explain about the scheme and why we are where we are. Not to argue about the technical details, but to give the general background. And it might also be an appropriate time at which one could use the 3D fly-through model, which is about 15 minutes, by way of introduction to what then is to come in the discussion of the various topics. Now, that doesn't fit neatly into the normal pattern of a hearing or inquiry, but I did want to raise that as a possible procedural step in the course of introduction.
Could we not deal with that in our suggested background hearing session?
I just wanted to make it plain so that that's what we had in mind, that we would ask somebody to sort of walk through it.
So you're in agreement that that's a useful mechanism?
And subject to that, I have no issue with the hearing session for introductory and background. Thereafter, having reviewed a number of the comments made, the position on this side is that, no, I shouldn't say on this side because it's not adversarial, the position of the council is that they have started to wonder whether in fact hearing sessions might be more appropriate for a number of the topics that are currently allocated to inquiry sessions to enable discussion of whatever matters are then outstanding in the method that you have currently outlined. Therefore, they would be content broadly to run hearing sessions for all topics if that was thought appropriate. If it's thought otherwise, that an inquiry session, for instance on technical matters, is required, then so be it, and of course the council would comply with that. Certainly in visual and heritage impacts, we did wonder whether that matter could be dealt with, particularly by a discussion rather than by the leading of the formal witness process. But again, we're content to await comments of others and your views, sir. So far as the other matters, generally called town centre, and the wrap-up one, dealing with a variety of issues, content with hearing on these, and there's an engagement session, just to take that as a general label, slipping in there, again content with a hearing session on those. So I think that, I'm trying not to be too rigid about these matters, but that's broadly the council's position.
If I may summarise that, then you're not necessarily unhappy with our suggestions. You would also be happy with hearings for all the topics. Is that fair? Okay, thank you. First, Save Our Sands. Any thoughts or comments on the actual mechanism we should use for hearing your objections?
Yeah, are we okay? Yeah. Yeah, if I could respond and respond partly to that. I made the point earlier that if we have hearing sessions, that may make cross-examination quite difficult. I thought the whole point of the formal inquiry was that we really got down into that. And I think that might be difficult to achieve in the way that we would be content in a round-table discussion. My view is that all of these subjects at some time or other in this inquiry will have to be subject to cross-examination, because we do want to put detailed questions to officers of the Council about aspects of all of these subjects in some way or another. I'm quite happy with the hearing on background and context, your first one, as long as it includes, and we would suggest including in that, councillors from Dumfries and Galloway Council, because we need to understand the background to the political decision that was taken to confirm the scheme. And they need to come to this inquiry and account to the people of Dumfries as to why they actually took that decision back in May of that year, when the advert had only been put out a month or so earlier, how they were so sure that this was the scheme is most interesting. And I think it would be interesting for you as reporters to be aware of that. So if we're going to have a discussion about the need for the proposed scheme, the legislative background, the policy background, and the Council's reasons for the order, then let's have a round-table discussion. But let's widen it out a little bit and get the real people here who could be called upon to answer some questions. Can we take that one first?
Well, I'm grateful for your agreement for a hearing session. Dumfries and Galloway Council is represented. They will be represented at that. They will be represented at that hearing session, and it will be for the council to decide who it brings along. We need to look at the order that is before us. We can't revisit votes that were made in a chamber. So what I'm hearing from you is that you would rather have inquiry sessions for all the subject headings.
Yeah, absolutely, because there is no way. I fully understand why the Council want to have hearings. A round-table discussion, that's nice and easy, isn't it? You know, there's no real cross-examination here. There's no real thorough examination of what's happened here. Yeah, I've got to say, look, this is far too important. This is a public inquiry. My view, I don't know if others agree, is that we will at some time or other, throughout the process of this 7 weeks, need to cross-examine people on all of these issues, and we need to cross-examine them effectively. And I'm not convinced that that can be done in a hearing session, particularly if we're going to be subjected to videos and walkthroughs. If we're going to get that, then we'll do some walkthroughs as well. The best walkthrough you can do is just walk along the sands as it is just now and see the state it's in. We can do walkthroughs too.
Right, let's not get bogged down into what evidence we're actually going to lead. I'm just looking at the mechanism. So what I took from that is that you're content for a background hearing session, you're content for a wash-up hearing session, but all the other ones should be an inquiry session. If we were to pose for that, would you agree with it?
Well, I'm looking for some guidance from my colleagues here, but the point I'm trying to make, I think I've made it, is that I don't think hearing sessions are going to get to the... round-table discussions are very nice and very cosy, but I don't think they're going to get down to the detail that we require.
Right. Well, as I say, I've recorded your and I'm happy to go along with that. I'm happy to have inquiry sessions. It's not a problem. any other parties present a view on the mechanisms that we should discuss? Right, this gentleman at the end here.
Sir, I'm a resident from the rural areas. What I would say is that looking at your Annex C, you talk about inquiry sessions. You've listed a number of people. If we're going to have an inquiry or an inquiry, whether it's going to be verbal or written, I've come along today basically to give you my thoughts along the headings of which you've produced, of which I'm quite happy to go along with. How are you going to take the individuals that you've got down in potential parties to hear them have their say?
Well, perhaps I misunderstood you. We're not hearing any evidence today. This is just about procedures. So those were the parties who replied to our survey, and we asked for people's views. In terms of a detailed timetable, once we've agreed that what the topics are going to be and what the method is, we will be able to issue a detailed timetable, so people will be offered a slot. So if you, sir, wanted to give evidence at an inquiry session on technical matters, we would be able to offer you a slot, and that would be the same for everyone who indicated that they wish to provide us with additional evidence orally. Does that answer your question?
What I was thinking is that if these people are subjecting themselves to an objection or even an acceptance of the plan, are you not going to listen to them as an individual, which will then, they will be able to cover all those topics on that one occasion?
Right. So what you're saying is rather than break up the inquiry into topic, we hear each objector in turn.
Yes, I am saying that actually, or otherwise you'll miss the points.
Well, that's fine if there's only a few people. But it becomes a problem if everybody just comes along and covers everything, then it's very difficult to organise it that way, and it's difficult for the council to have the right witnesses available to respond. So if there's lots of people wanting to give evidence at the inquiry session, then it's much better for it to be broken up into topics. Now, if there was a particular submission, well, let's leave it like this. We could take a view once we've seen the detail of what people want to submit, and we would do our best to accommodate things, so we weren't asking everyone back 5 times.
If I may just say, sir, the potential parties of which you've noted on Appendix C amounts to around about 20 people. That is not going to take an unduly lot of time. I mean, my brief is very brief, but it needs to be heard to indicate the topics and the importance of those items.
If we'll come on to this later on, but if you're going to give us evidence at an inquiry session, part of the requirement is to prepare an inquiry statement, and that will give us clues as to what it is you're saying. And if it is brief, then I'm sure we can fit you in appropriately. Anyone else in terms of the mechanisms available? You've heard the different suggestions. Chap there.
Yes, good afternoon, sir. My name is Peter Ferguson. I'm a solicitor and I represent Historic Environment Scotland. HES has not participated in the process to date. They were not a statutory consultee. They were, however, invited to attend this evening's meeting. And before we give a view on the most appropriate form of procedure, it would be helpful, sir, if you could outline firstly why Historic Environment Scotland had been invited and what participation you would anticipate them having.
Our initial reading of the material before us indicates that the scheme may have an impact on the bridge, which is listed on a scheduled monument, and there's also a listed building. I think the museum is listed, and that is matters which are raised by objectors. I know you didn't comment on the actual scheme, but I'm aware that Historic Environment Scotland have liaised in the past with the council in the preparation of the scheme, and I think we would find it very helpful to understand Historic Environment Scotland's position in terms of those impacts, and in particular, if the scheme was modified, how that impacts on Historic Environment Scotland's areas of interest.
And which particular hearing or inquiry sessions would you envisage HES being involved in?
Well, we were thinking the background session and the backstop session, if that makes sense.
Yes, it does.
Who else had their hand up? I think a gentleman there at the front.
I think you've already ruled on this, but just for my benefit once more, since it's my means of presenting an objection, can I put an X under further written submissions in technical matters?
If that's what you want to do, that's fine. That's absolutely no problem at all.
And so that in some more detail, hopefully. But so that would be taken account, and here it's down as an inquiry session. That's people are being questioned and so on, cross-examined. But further written submissions, how would the two of those square together?
If there are, the starting point is that we'll consider every objection. If people want to give us additional evidence to expand upon the objection, if they want to give us further written submissions on any topic, then that's fine, and we'll take that and we'll put that in our report. What we're discussing now is if objectors wish to expand upon their original objection by giving oral evidence, what we're discussing now is how that should be done. So if you want to make further written submissions on technical matters, no problem.
I have already done so,
right? And
I just see here my concern is that you're only going to deal with them by the inquiry session.
No.
Where will they come in?
That noughts and crosses is not really for that purpose. So if you provide us with further written submissions, we'll have it and it will be in our report.
Hang on. You've got it here under impact on town centre. Cross. Where I'm interested, I just don't want to see it slipping through the cracks, that I'm interested in impacts elsewhere under technical matters. I have already submitted a further written objection on that. You say you're going to deal with it. It's further down the agenda. See here, item C, it's 6. Then I just want to make sure, does it get discussed at the same time as you're dealing with technical matters with an inquiry? Or whereabouts does it get discussed? Are you going to talk about this later? That'll be fine.
If you want to put further written submissions in, just put them in.
I've told you I can.
Yeah, that's fine. And that we'll be considering that. And that's the end of the matter.
Oh, when?
Well,
what point? When that topic comes up? Under the inquiry session, is that when you'll take into consideration further written submissions on that point? Or when?
We're setting a timetable for further written submissions on all topics, and that will be in 5 weeks after this pre-examination meeting. So it's a separate matter. Don't worry about the crosses on that diagram.
As Susie said, don't worry about it, about the crosses. So this is, you're purely now, we could forget everything in that column, further written submissions. You're only talking, at this moment, about the inquiry or hearing session. Oral statements, if friend here, as he says.
There's no. If you want to, I know you've already done it, but if you want to put some more further written submissions in, providing you meet the timetable, which we'll talk about in a minute, then there's no problem with that. Someone else had their hand up. I think Mr. Mundell at the back had his hand up.
Yes, I would like all of the sessions to take place as inquiries, including the background session at the beginning. I'd also like to suggest that the ecology is included within the technical matters, as some alternative proposed designs for the scheme may open up new questions about ecology on the river.
And why do you think an inquiry session is helpful in terms of background for us?
I think that it would be helpful, as a number of previous decisions around flood defences on the River Nith that have either been abandoned, changed or discarded are relevant points. I also think there are a number of policy questions around how different pieces of legislation might interact, and I think it would be wrong to close off the opportunity to cross-examine any witnesses that the Council wish to suggest. I also think if they wish to go through some of the walkthroughs, modelling and other aspects of the scheme, at that stage it's important that questions can be asked about the design presented.
I mean, I wouldn't want you to be under the misapprehension that no questions are allowed at hearing sessions. It's not that it's a slightly different format, and the way it will work is that we receive the statements from the parties who wish to participate in the hearing sessions, and then we prepare an agenda, and that is items that we wish to discuss, and we start off that discussion by asking a question of one of the parties present, and after the answer we go around the table and hear everyone else's comments. So it's not the case that no questions are ever asked at hearing sessions.
I don't think, to be fair, that's what I suggested, and I believe yourself and I have met in the Parliament and discussed in detail how these sessions typically work. I think that it's only right that we have a formal opportunity to cross-examine and to bring in alternative witnesses at that point who may be able to give professional and other comment on some of the evidence the Council intend to present.
Thank you. So you're actually asking for all matters to be dealt with by inquiries?
Correct.
Okay. Anyone else? Just there's another chap behind you.
Hi, my name is Barry Dunn. I work for Scottish Natural Heritage, and I note on the subject matter of impact on ecology that it's defined as sufficient material already been made available. And I am wondering, is it possible to change our participation in the background and context session from a hearing session to a further submission, given that there's been no objectors, as you said earlier on, to any of the ecological impacts on this proposal? I take Mr. Mundell's comments about any changes to the scheme may have additional or may have new and unrecognised ecological impacts at a later date, but that would be a different scheme and that would need to be reconsidered, so it wouldn't be part of this public inquiry.
Okay. I mean, I think we would find the presence of SNH very helpful at a hearing session on to give us the background of your involvement in the scheme, rather than just further written submissions. But I hear what you say. There was another gentleman at the front.
Yeah, as a lay representative from Nunham, I'm unsure as to what constitutes the best value for this, whether it's an inquiry or a hearing session. Mm-hmm. My instincts were that we were coming to inquiry session, so that was the basis of my thinking. Will council be represented at the hearing sessions by Pinsent Masons?
It would often be the case, yes.
Yeah, on that basis then it does go back to the fundamental point we made at the very start of this meeting, that as lay members entitled to attend those hearing sessions, as we assume, along with any other person, I think quote yourself, who had an interest, then it would once again, I think, place us at a severe disadvantage and prejudice our views if we are arraigned by formal legal representation from the other parties and by the experts from the other individual SNH and so on and so forth who have been involved in these hearing sessions. So I would feel that we would be very much at a disadvantage in those hearing sessions without the opportunity to make formal approach within an inquiry session.
What is your advice to us then? Are you saying that all sessions should be formal inquiry sessions?
Well, as I said at the beginning, I'm a lay person, and so I find it very difficult to come up with what I feel is the best way forward for everybody concerned. I appreciate what you're trying to do, sir, and I appreciate that what you're trying to do is get a sense of the best way forward here, and we certainly will not object to any way forward that is taken in the final analysis. I just have no ability, and I don't know if my colleagues from Nunham have any similar ability to make a judgment about what is the best way forward. So I think from our point of view, it's a question of we go forward with whatever is presented before us. But I make the point, as I've made it again, it's repetition, that unless we have the opportunity to have somebody in our corner who can pick out the legal issues or the technical issues, we are at a disadvantage.
I know that. I do recognise that if you're not familiar with inquiries and hearings, then it must be very difficult to make a judgment. Is there any other points? There's a gentleman at the back, Jane.
Just while the microphone is heading there, so can I just ask a point of clarification about HES? Because I note that the visual and heritage impacts session, whatever that turns out to be, includes impacts on listed buildings. And I did wonder whether if HES were participating in the process, that might be a point at which they might have been involved. Now, I'm not leading them, but they have been brought here. So I just wanted to raise the point so that it was clarified, because, of course, we were also suggesting a hearing session there, but that's the only point I wanted to make.
Well, thank you for that. I mean, these sessions are, of course, an opportunity for objectors to lead evidence to us, and Historic Environment Scotland haven't objected. Sorry, sir, carry on.
Donald Robertson, resident in Dumfries. A number of people might find it rather difficult or intimidating to come to a session and give evidence, and as the gentleman in the centre said, it may be preferable for them, rather more difficult for yourselves, for the oral evidence of individuals to be given in one session covering a number of the subject matters which are set out in Appendix A.
Okay, I hear. What I can say is that we will use our best endeavours when we see what people. If people wish to give evidence orally by way of an inquiry session, we will use our best endeavours to offer people slots so that they are not having to turn up lots of times. I think that's all we can do. Anything else? Right. There's some hands up over here. So just bear in mind, what I'm looking to do is canvass opinion as to how we should hear orally the evidence for those objectors who wish to supplement their original objection. You will know that there's mixed views at the moment. So I hope that the future people are going to help us. Any thought?
Thank you. My name is Malcolm Johnston. I'm a councillor for Nith Ward. It's to go back to what we were discussing earlier, actually. I think to get the background to this scheme, I think it is important that you speak to elected representatives. It's a big part of the background to this entire scheme, and I think you would really need to hear it. I also wondered, as a separate question, you've got down here, including. Does that word including mean limited to, or is it broader than that?
It's broader than that. We're not trying to limit or restrict evidence that people are giving, but for us to collect it in a structured and logical way, we're trying to people who want to give us evidence on technical matters. That's the session that it would be better to hear that in.
No,
sorry.
As to the hearing from elected representatives, could you answer that?
Well, it's for Dumfries and Galloway Council to decide who they put up. If there are elected members who are objectors, then we're happy to hear from them.
I'm just wondering if there's a suggestion that you're proposing walkthroughs through the Whitesands and everywhere that it could be suggested you have a walk through Nunham, and that the reporter and people come and actually have a look at the impact in the site that is actually going to be impacted, and shouldn't just be viewed as a flood defence for the sands. It's the impact that flooding is then going to have further upstream, so perhaps a bigger picture needs to be looked at.
We're very happy to visit any site. Had the hand up.
My point was just a simple one. I admire the way you said 7 weeks will do it. Is that correct? How long is a day in your week?
Well, we usually start at 9:30 and we'll finish at 5.
And how are you going to publicise some of the comments and things you've heard as you go along? Because I would have hoped this was an iterative process, that there was a learning point not only for you but for the people who are submitting things.
The purpose of the inquiry is for objectors to expand upon their original objection if they so wish. All the evidence, additional evidence that is provided, will be on our website. I think I've heard from everyone. I'm desperately trying to find a way forward as to how we go about hearing the evidence. Is this going to help me?
Can I clarify that if there was an inquiry session for the background, it would be open to objectors to the scheme to call on elected members from Dumfries and Galloway Council as witnesses?
If you wish to present evidence at an inquiry session, it's up to you who you wish to call. Right, I think there's some food for thought for us there. So we've had our suggestion, we've had the council suggestion that it should be mostly hearing sessions. We've had the suggestion that they should be all inquiry sessions. I'm going to hold an adjournment now for 10 minutes for us to have a little think together to see how we should best proceed. So if you would come back, let's say 10 past 6. carry out an inquiry into the objections that have been made to the order. Anyone who may, if you're happy to rely on, well, all objections will be considered. If you want to add to your original objection by further written submission, then that's fine, and we'll discuss how you do that in a minute. If you want to expand on the contents of your original objection by giving us oral evidence, as you heard just now, there are mixed opinions as to how that should be dealt with. So what I am going to suggest now is that we want a background hearing session, and SOS and Mr. Mundell are very welcome to join that hearing session, because we have questions that we want to ask both the Council and the statutory consultees. If Mr. Mundell and Save Our Sands wish to have, in addition, a background inquiry session, then that's fine. I would be grateful if you could drop us an email over the next few days to expand upon the subjects that you're likely to be dealing in that. I think we're going to have to go for inquiry sessions on technical matters, visual and heritage, engagement and town centre. But we, again, for our own purposes, in terms of writing the report, we think a hearing session for what was described as the backstop, the options that might flow from modifications, etc., would be the most appropriate for our purposes. So that is our suggestion. Is that acceptable?
Do you want me to go?
Sir, at the moment, we haven't still decided on when you're going to listen to the individual oral. You've talked about if one needs to expand on what the evidence was previously written. That can be done, but surely in a situation such as we are, we need to give this verbally. And we need to establish when. I think the SOS and the Council are two separate entities, but to listen to the individuals is most important, and I'd like to know when that will take place.
Well, we will discuss that. If you wish to give oral evidence, then there'll be some sessions, and we will try and slot you into one of those sessions.
There's only in a point of procedure. You mentioned SOS would be at that background hearing. I presume that other objectors and non-objectors would be entitled to be there as well.
Right. Well, I'm taking that as... Oh, Mr.
Almost. No chance. Sorry. Right. I just want to clarify it before I agree to it. Right. On the first one, background and context, you're suggesting that there will be a hearing session, but also Mr. Mandela and ourselves could have an inquiry session. Is that correct? But we need to write to you and lay that out. Yeah. Well, I'm happy enough to agree to that if Mr. Mandela is happy to agree to that. Okay. Now, if we can just take the others quickly. Technical matters, you're saying an inquiry. Visual heritage, you're saying an inquiry. Impact on town centre. I didn't quite catch what you suggested there.
Well, that's all the matters that we agreed we would cover under that. So that's what we listed in the agenda, plus your additional things about... compensation scheme and parking regulations?
Yeah, but would that be an inquiry or a hearing?
Inquiry.
Right, I'm happy to agree to that, right? So that only leaves the last one. What are you suggesting there?
So we're suggesting a hearing session for that.
I can live with that, yes.
I'm taking that as agreement. So there we go. So let's move on to item 6. And we will set all this out in our note of the meeting. You don't need to go back and watch the TV to record all this. So we've just agreed the matters we will hear orally at inquiry sessions. So if we go to agenda item 6A, what we will include in our note of the meeting is for objectors to indicate which of those sessions they wish to participate in. And if it's more than one, as we've said, we would use our best endeavours to just hear the individual at one point in time. If you are giving evidence at an inquiry session, there are certain things you need to do. You need to provide an inquiry statement setting out an overview of your case, the witnesses you wish to call, the documents you are going to rely upon, and an estimate of the time for giving your evidence, and when you're going to be available during that block of time. And we would like that inquiry statement 8 weeks before the inquiry is due to start. So that's, well, we'll come on to dates in a minute. For documents, so a document is any plan, photograph, report that you seek to rely upon. That needs to be available 4 weeks before the inquiry session. And your precognition, which is the evidence you read out, it's your evidence, unless your precognition is more than 2,000 words, in which case you write a summary precognition, and it's the summary that you read out. That needs to be available 2 weeks before the inquiry.
Can I just clarify something? The statement and the precognition, are we allowed, if it becomes necessary in the discussion, to divert from that, or can we only stick to that?
Well, the purpose of the whole point is that the principle is there should be prior notification of evidence. So again, forget every courtroom drama that you've ever seen where on the last minute someone pulls out evidence that no one's seen and the guy gets off. That's not how it works. The whole point is that all parties, yourselves and the council, can understand beforehand the nature of the arguments that are going to be used. For our purposes, the inquiry statement is really, really helpful and essential to actually do some programming, so we can see from that what slots we should offer. Is that okay?
Thank you.
Okay. So if you choose to present additional evidence to us orally using those inquiry sessions, those are the requirements that you need to follow. Is that okay? For the hearing sessions, so that's the background and the backstop. You need to provide a statement 4 weeks before the inquiry starts. Statement and documents 4 weeks before the inquiry start. And we will issue an agenda 2 weeks before the inquiry starts for those sessions. Okay? For further written submissions, again, if you want to expand on your initial objection by writing further written submissions, that's fine. There's no restriction on the topic, no restriction on the word length. If the objectors could have those in by Friday the 5th of September, and the Council would have an opportunity to reply by the 12th of October. Is that okay? So the Council to respond to any further written submissions in writing by the 12th of October? Okay. If you're relying on your original objection, there is no action necessary. We wondered whether the Council wanted an opportunity to respond to any of the original objections, but perhaps that's something you could wrap up in your comments on any further written submissions. We also thought it would be useful for there to be closing submissions, and that would cover all matters. It's not compulsory, but if objectors wish to make closing submissions on whatever was discussed at their particular event, a closing submission is pulling together the conclusions you wish us to take from the evidence that we've heard. We would receive those, and we'll take into account the fact that it's possible that Christmas may come upon us. We'll give 2 weeks for objectors to put in their written closing submissions, and the Council would have 2 weeks after that to respond. Is that okay?
Were you anticipating, sir, this at the end of the inquiry encompassing everything that has gone before?
Yes.
Thank you.
Right, so that's item 6. So if we move on to item 7. We've agreed that a 7-week block of time is reasonable. We'll obviously review that when we get the inquiry statements in. Obviously the inquiry sessions are the ones that will take the time, and we'll look at that then. But if we're proposing to start on the 6th of November, and when we get those inquiry statements in, the case officer will be in touch with those who've indicated they wish to take part and offer slots. And there may be a little bit of jiggery-pokery, but we'll try our best to fit everyone's needs in. Is that okay? So we start on the diary in, starting on the 6th of November and nominally finishing on the 21st of December. We sit Tuesday, Wednesday, Thursday, Friday. Okay? Everyone
yes,
clear?
Sir.
So I know colleagues are going to be making further written submission, and again, re-emphasising our lay position, I do feel that we would perhaps need longer than 5 weeks to prepare those written submissions for the 5th of September. You'll appreciate that I have to go back to people who may be on holiday at the present moment, and they need to make contact with various people. So I'm just concerned at the timescale. I'm offering my concern. We'll play by the rules if they're there, but I am concerned at the length of time available to us.
What do you think would be reasonable?
Well, I would have extended by another 2 weeks, frankly.
Councillor, any thoughts on that?
Well, the only issue on this side, so apart from the fact that the inquiry, taken generically, involves the preparation of a large number of different matters, it would be the preference here to get the matter of written submissions and responses dealt with well before the inquiry is about to start, otherwise you get into all kinds of practical difficulties. So if it is possible to maintain your proposed timetable, that would be preferable from the Council's perspective. I understand the difficulties.
Let us leave it at this, that we'll stick to our deadline of 5th of September, and if there's any reasonable requests for extension for particular circumstances, then we'll consider those requests as they come in. Right, so that's the dates. Venue.
May I just ask this question? You talk about the session starting the 6th of November and finishing around the 20th of December. I will be away from the 1st of November until the 1st of December, and I wish mine to be an oral situation, if at all possible. So how do I go about that? Should I write to Scott Mackenzie and just say, please slot me in on one of the slots of which the you as chair have mentioned after the 1st of December? Or will that not be possible and I have to submit it in a written time?
Right. Well, when you submit your inquiry statement, we will be able to see how long it is, and we'll be able to offer you a slot. Part of the purpose of the inquiry statement is to indicate that you will be away, and so we'll know not to offer you a slot in that time. Okay?
If I just say so, just for the benefit of the members of the public present, if a situation like that arose and an individual was unable for some reason to appear at what might be the logical place in the inquiry, I think you can take it, Sir Madam, that the Council would happily cooperate in allowing them to be heard, as it were, out of place in order to allow their evidence to be heard.
It seems scary at this point, but actually we've always been able to manage to slot people in on every other inquiry I've done so far. So, fingers crossed. So, we've done dates. Venue. Is this a suitable venue? Does anyone have any other thoughts on venues?
Could I express a preference for the Cairndale Hotel as being more in the town centre?
Yes, simple.
Just a preference, but it depends on whether that suits others.
Would that be big enough, do you think?
Well, it's something handy for the council.
Okay.
I would have thought they would have. I'm not sure, but I would have thought they would have had a room. They've got rooms certainly as large as this, haven't they? Right. So, any other suggestion? I have to say, Mrs. Robertson and Mr. Mackenzie will tell you how difficult it is to find the perfect venue. Obviously, it has to be available for a long period of time. There's various checklists it has to meet, and the cost. And we might be competing with Christmas parties and blah blah blah. So it may have to be more than one venue. But can I leave it that if anyone has some good ideas, that they will let Mr. Mackenzie know. If I ask the council, perhaps as well. We actually have a list that we've acquired over the years of decent venues in various places, and I think we'll just have to leave it to Mr. Mackenzie to try and find the best available. If we're happy to that, are we done? Can we now move on to item 8? So the normal housekeeping would be that we would open the inquiry at 10 o'clock, but all other days would be 9:30. We would have a morning, dinner time and afternoon break at appropriate moments, and we would aim to finish about 4:35ish, depending on the flow of evidence. Is there anything else on housekeeping that we need to discuss? Okay, moving now on to item 9, site inspections. We have already visited the area generally to familiarise ourselves with the area as preparation for today's meeting. We will make our own arrangements to visit
where it's possible to, public areas, on an unaccompanied basis for things that we think, oh, that's interesting, I should have a look at that. But we're also happy to have formal accompanied site visits. They need to be accompanied either because parties particularly want to show us something, make sure that we see what they thought. They need to be accompanied if it's on private land, because we can't wander around land on our own, or if there's any health and safety issues, if you want to send us down a sewer or something. We would welcome suggestions. So if parties can think of anything, and we'll see if we can have an itinerary. Normally what happens is that during the process of the inquiry sessions, particular matters come up and people say, well, you should see that. So we'd have a list, and at appropriate moments, spare moments during the 7 weeks, we would make arrangements for site visits. Does that seem okay?
Yes, sir.
Right. Other procedural points. All our contacts and the website, etc., will be set out in the note of our meeting. I would say that we will be working electronically at the inquiry. We work off wee tablets. So we prefer that evidence is submitted, electronically. And if you just send those to the case officer in the first instance, and the case officer will take responsibility to make sure those are distributed around. Again, that's a lot easier if it's done electronically. All documents that come into us will be displayed on our website, so you'll be able to see what other people have given us. And we would prefer Word or PDF files. And if it's a very large file, it's to break it down in some way, or at least speak to the case officer as the best way of transferring that, so we don't completely gunge up our server. I would also add that generally these inquiries are evidence-led, so it's for parties to give us the evidence. But if at any point we feel that we need to have questions or points to clarify about any of the material before us, then we will get the case officer to contact the people in writing with our questions. Okay, any other points that I've missed? Gosh, I'm at the end of my agenda. Sorry? Oh.
I'm Lorna McLean. I work for SEPA. We were invited to attend this evening. We didn't object to the proposals, but I'd just like to clarify what sessions we would be expected to attend.
We would really like your presence at the background hearing session and the wash-up session at the end. Well, SEPA aren't objecting. They're not an objector.
Okay, does that mean we would have to call them as witnesses then?
You're entitled to call whatever witnesses you are. Bear in mind, you have no rights to insist. Again, forget these courtroom dramas where you subpoena people. You cannot do that. Okay, are we done? Is there anything else that... Mr. Mandel?
Yeah, I would just be concerned in relation to our inquiry session at the beginning into the background, that we'll have a number of organisations appearing in the hearing session, and the point of having that inquiry session was to allow us to cross-examine some of those organisations. So I think it would be helpful if anyone appearing in the hearing session was open to us in the inquiry session to ensure that we can pursue the lines of questioning we intend to.
I was assuming you would attend the hearing session, and you'd be perfectly entitled to ask questions at that hearing.
But as you know, and as is discussed, the format of the hearing session is different to that of inquiry, and I wouldn't be 100% confident that we would have the same level of cross-examination as if we were to have the same individuals appearing at our inquiry session.
Well, this inquiry is objector-led. You're an objector, Mr. Mundell, so if you want to add to your original objection by coming along to a background inquiry session, then we're very happy to hear from you. And if you turn up to the background hearing session and have questions to us of the other matters, then again, you're very welcome to do so.
I just feel that doesn't, again, put us on a level playing field, because if you're organising a hearing session and you're leading the questions as the reporters, then it's likely these third-party organisations will attend that session. And you've pointed out to Mr Dowson already that we wouldn't be able to compel the same organisations to come to our inquiry session. And when I was content to let that happen, I assumed that at least those organisations would have to be subject to questioning through the formal inquiry.
I would not stop you from asking a question at the hearing session.
Could I comment? It's going to be important from our point of view to be able to put detailed questions not only to SEPA but to SNH and HES as well. I know there are representatives here. We also haven't covered at all the role of Scottish Water, and I think that's very significant here. And at some point we will want to put detailed questions to all of the representatives of these organisations, and I'm not convinced that the initial background hearing is going to be the right sort of theatre in which that can be done. Because if you look at the technical matters where we get into things like drainage, then it's going to be very important that in that technical inquiry we are able to speak to the people who know about drainage, Scottish Water for instance, and certainly I would have thought SEPA would have a contribution to make there. So I really would find it very difficult to have an inquiry without those organisations being present.
Well, we need to remember what this inquiry is about. The Council have published an order and you've made an objection. The inquiry is an opportunity for you to expand on your objection. SEPA, Scottish Water, the others, as I understand it, have not actually made an objection. There's nothing stopping you having discussions with these parties beforehand in the help of gathering evidence. And there's nothing, and it is open to you in your evidence to tell us whatever you want about these parties. But the inquiry is about the original objections.
Yeah. Okay. Well, our original objections mentions all of these bodies, so that's okay then.
Hey, I've come to the end of my agenda. Does everyone know what it is they're doing? Great. Right, on that basis then, thank you very much for coming along and for your cooperation. Yeah, you wouldn't believe this, but it's actually slightly shorter than I thought it might have been. And it does mean I might get back to Falkirk and have a pint of beer tonight. So thank you very much, and the next time you'll see us is on the 6th of November when we open the inquiry.